Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
In October 2017, AAA was deployed to the Kingdom of Saudi Arabia as a cleaning laborer under a 2-year contract with a monthly salary of 1,500 Saudi riyals through the recruitment agency Bison Management Corporation. In January 2019, after 15 months of work, AAA underwent a routine medical exam which revealed that he was positive for the human immunodeficiency virus, or HIV. As a result, AA's foreign employer terminated his employment, citing Saudi Arabian laws that deem people living with HIV unfit for work. Consequently, AAA was repatriated to the Philippines in February 2019. AAA then filed a complaint for illegal dismissal, which was dismissed by the labor arbiter. The National Labor Relations Commission reversed the labor arbiter and found Bison, its president, and its foreign recruitment agency, Saraja Al Jazeera Contracting S, liable for illegal dismissal. The NLRC was affirmed by the Court of Appeals, prompting Bison to elevate the case to the Supreme Court. In another case, a female teacher was hired in 2007 to teach grade school at the Bohol Wisdom School, a Christian institution. She was granted regular status in 2010. On September 22, 2016, while she was 2 months pregnant, the school principal verbally suspended her and informed her that the suspension would continue until she married the father of her child. 5 days later, she received a written notice stating that she was suspended indefinitely without pay due to immorality, pending her marriage to her boyfriend. The teacher filed a complaint for illegal suspension and illegal dismissal, among others. The labor arbiter ruled that she was constructively dismissed, but the National Labor Relations Commission reversed this decision. On appeal, the Court of Appeals upheld the NLRC's ruling that there was no constructive dismissal, but found the teacher's suspension to be illegal. Both the cases of the overseas Filipino worker and the grade school teacher were elevated to the Supreme Court. Can an HIV diagnosis or becoming pregnant out of wedlock be considered valid grounds for dismissal or suspension? Hi, I'm Attorney Mike Navallo, Supreme Court Chief Communications Officer. It's the 2nd of May 2025. In the conclusion of this 2-part episode on labor disputes, we talk about illegal dismissal and suspension of employees due to an HIV diagnosis and pregnancy out of wedlock, within the context of the cases of Bison Management Corporation versus AAA, GR number 256540, decided on February 14, 2024, penned by Supreme Court Associate Justice Alfredo Benjamin S. Caguioa, and Bohol Wisdom School et al. Versus Mabao, GR number 252124, decided on July 23, 2024, penned by Supreme Court Associate Justice Ricardo R. Rosario. And joining us once again to talk about these cases is Undersecretary Filemon Javier, who heads the Legal and Legislative Affairs Strand of the Department of Education and was most recently a Labor Law and Social Legislation Bar Examiner for the 2024 Bar Examinations. Hi, Usec Javier. Thanks again for joining us, and welcome back to the Supreme Court Podcast.
Hello, Attorney Mike. I'm happy to be back.
All right. It's great to have you back, Usec. And first off, our listeners should have noticed by now that we have refrained from identifying the person living with HIV in keeping with how the person is referred to in the text of the case. Explain to us briefly, Usec, why we use the initials AAA, and when is this convention used?
Okay, Attorney Mike. The Supreme Court respects the confidentiality of information and protects the privacy of respondent AAA. Our courts follow a certain protocol as encapsulated in amended Administrative Circular 83-2015, wherein it applies to cases where confidentiality of identities of parties' records and court proceedings is mandated by law or by the rules. Incidentally, with respect to HIV or AIDS, we have a law. There's a particular provision in the Philippine HIV and AIDS Policy Act wherein it is guaranteed that the confidentiality of persons tested for HIV or exposed with HIV shall remain to be confidential. So that is why the Supreme Court in this case refer to the individual as AAA and not using his real name.
All right. Thank you for that explanation, Yusek. And what's interesting about this case is that in justifying the dismissal of AAA, the agency cited the laws of Saudi Arabia, which supposedly treat an HIV diagnosis as a basis for terminating employment for being unfit to work. In contrast, here in the Philippines, do we have laws similar to this?
Mm, in the general sense, we have a law, particularly in the labor code, wherein disease could be a ground for termination. It stated there that an employee may be terminated from his services if he or she is found to be suffering from any disease and whose continued employment is prohibited by law or is prejudicial to his health or his co-workers. The only requirement there is that there must be a certification from competent public health authority that he could not be cured within a 6-month period, even with sufficient or proper medication. But with respect
Mm-hmm.
to HIV, Attorney Mike, there is a more specific provision in the Philippine HIV and AIDS Policy Act, wherein there is a non-discrimination policy, which means
Mm-hmm.
that it is prohibited to reject job applicants or terminate his or her employment and other discriminatory act on the basis of solely or partially because of the actual perceived or suspected HIV status. So in the Philippines, it's different. No, if in
Mm-hmm.
Saudi Arabia, it could be a ground for termination because it's deemed the person is deemed to be unfit to work. Here in the Philippines, there is a non-discrimination policy.
So in that case, Yusek, which law will prevail? Is it the laws in the Philippines or the laws in Saudi Arabia?
Okay. Um, in instances wherein the laws are conflicting in a sense, then we have to decide which law will prevail, right? I
Mm-hmm.
two concepts come into mind. No? The first concept would be lex loci contractus, which means that it is the law of the place where the contract is made, and the other
Mm-hmm.
one would be pacta sunt servanda, which means that the agreements must be kept, no? But because we are talking about employment rights and illegal termination disputes of employees, almost always in instances like this, to protect the rights of the employees, it is the Philippine law which will govern.
Mm-hmm. Are there exceptions, Yusek, to the application of the lex loci contractus principle, such as in this case?
Yeah, there is an exception, Attorney Mike, but we must note that this exception is so narrow. It is strictly
Mm-hmm.
construed because we are talking about employees' right and protecting the security of tenure of the individual. The
Mm-hmm.
courts almost always will use Philippine law because Philippine law, as we know, is pro-labor. Philippine law protects the Philippine citizens. But in a very strict, in a very narrow exception, it is entirely possible that the parties may agree that a foreign law shall govern, but subject to concurrence of 4 requirements. And
Mm-hmm.
if you will allow me, Attorney Mike, let me
Please go ahead, Yusek.
enumerate the 4. The first requirement is that the overseas employment contract must expressly stipulate the foreign law to be applicable.
Mm-hmm.
The second, that foreign law, which is invoked normally by the employer, must be proven before the court pursuant to our rules on evidence. And third, that foreign law stipulated in the agreement must not be contrary to law, morals, good custom, public order, or public policy of the Philippines. And fourth,
Mm-hmm.
finally, the overseas employment contract must be processed through the POEA or to the Department of Migrant Workers.
Mm-hmm. In this case, Yusek, the Supreme Court said two requisites were not met. First, the foreign law was not proven. Second, the foreign law is contrary to law and public policy of the Philippines. How so? Could you elaborate further what the Supreme Court meant?
Yeah. Okay. So first one, the Supreme Court said the employer failed to prove the foreign law. When the Supreme Court looked into the records, it was noticeably absent. The copy of the purported foreign law was noticeably absent. All that the company was able to show were agreements, news articles,
Mm-hmm.
collection of untitled documents, which would not amount to how you should prove a foreign law. So that's why the Supreme Court said the first element was absent because it was not proven.
Mhm.
For the second one, even assuming that the foreign law was proven to exist, and the stipulations of that foreign law to be applicable, the Supreme Court said in any event, it's contrary to public policy, it's contrary to Philippine law, it's contrary to our good customs.
And this is because of our law on against discrimination on HIV or AIDS, right?
That's correct, Attorney Mike. So because in Saudi Arabia, once the individual was diagnosed to have an HIV, it is a reason to terminate his employment because he is deemed to be unfit for work. That is
Mhm.
totally contrary to what we have in the Philippines, because in the Philippines, it's not a reason to terminate because of the non-discrimination policy. So even if that particular provision of law in Saudi Arabia was proven in Philippine courts, it will not be applied in our jurisdiction because it is deemed to be against or contrary to our laws or public policy.
Yusek, will it matter if there's an express stipulation in the contract that the foreign law will apply? For instance, in the contract, employment contract, for example, it says Saudi Arabia laws will apply.
Yes and no. Yes, in a sense, that is the first element of the for the exception to apply, right? That there must be an
Mhm.
express stipulation that the foreign law will apply. So in that sense, it's relevant that the parties agree which foreign law to be applicable. But no, in a sense that even if you put that in the contract, remember that the relationship between employer and employee is imbued with public interest, and therefore
Mhm.
applicable protective Philippine laws could not be rendered illusory just because the parties agree that another foreign law will apply. So in that sense, it would not be relevant if the rights of the Filipinos will be trampled upon by reason of that provision of foreign law.
And of course, we know that in this ruling, the Supreme Court said the dismissal of OFW AAA was illegal. Can you explain to us how the Supreme Court arrived at this ruling, Yusek?
Okay, because it is undisputed that the reason for termination is the finding of the diagnosis of HIV. And because that is not a ground to terminate in Philippine law, and because Philippine law will apply, the Supreme Court said the dismissal is illegal because there's no reason to dismiss. Because in the
Mhm.
Philippines, for an individual to be dismissed, there must be a just or authorized cause for dismissal. And diagnosis of HIV is not one of those reasons to dismiss.
Mhm. Yusek, let's go to the other case that we're discussing today. And this is the case of a grade school teacher who was suspended because she got pregnant out of wedlock. And the reasoning of the Supreme Court here, the Supreme Court ruled that her suspension was illegal. It goes on to say that sexual intercourse between two consenting adults who have no legal impediment to marry is not immoral. So, what is the standard of morality that the Supreme Court applied here? How can you say that an act is immoral or not?
Okay. In terms of the standard or yardstick, almost always, in fact, always, the Supreme Court would say that the test of morality would be public and secular. It is never
Mhm.
religious. So, in other words, actions prohibited or considered immoral if they are detrimental to the public or to the society. The community standards are used. So, in this particular case, premarital sex resulting in pregnancy out of wedlock um, was considered to be not detrimental to the society, so it's not considered to be moral.
Mhm. Wasn't the school justified, though, in saying that it was part of its management prerogative in keeping with its own standard of morality as a Christian education institution? So, in short, saying we are a Catholic school, we're a Christian school, so therefore we have the right to impose this so that our students can follow a good example out of teachers.
No, no, Attorney Mike, that would almost always would have a religious definition of morality. The Supreme Court
Mhm.
will always look to public and secular because the rights of employees must be protected, and therefore the standard to be used is not the standard used by individual schools, but the standards imposed by law and the standards that we have based on Supreme Court decisions. It is again public and secular. So in this
Mhm.
particular case, the Supreme Court, in many cases, in fact, has already declared that premarital sex between two consenting adults without legal impediment to marry is not considered an immoral act and therefore not a reason to terminate an employment.
Mhm. And in this case, Yusek, we know that the Supreme Court said that the suspension was illegal. Uh, Assuming that there was a valid ground for suspension, assuming that the reason was not was not related to religion or any religious morality standards, what could have the school done in this case to comply with procedural due process? I understand that's an issue here.
Yes, that's correct. The school here failed to comply with the proper procedure to suspend because in fact, the school admitted that it failed to provide the first notice. So for
Mm,
an employer to suspend an individual, much less terminate an employee, the employer must comply with the procedural due process requirement, which means that the number one, there must be a notice to explain, providing the employee the opportunity to explain, giving the employee at least 5 calendar days to provide a written explanation. And then after
mhm,
explanation is received, a second notice must be given to the employee, that is the notice of decision. These two notice requirements must be complied with so that the procedural due process requirements would be followed and the rights of the employees will not be violated.
mhm,
Case that procedure was not followed because again, the school did not provide the first notice.
mhm. But we also know, Yusek, I'm very curious about this. The Supreme Court said there was no dismissal in this case, only that the suspension was illegal. Were there factual circumstances in this case that led to the Supreme Court to rule this way?
Okay. Well, initially the employee was saying that she was constructively dismissed
Mm-hmm.
because the suspension was indefinite. And the court, in a sense, said that the suspension was not indefinite because at some point in time you will be allowed to return to work as long as you marry your boyfriend. So that was why there's no constructive dismissal. Second, there were return to work orders issued to the teacher, three in fact,
Mm-hmm.
and the teacher did not return to work. And
Mm-hmm.
in fact, the teacher said, I am no longer interested in returning to work. And so the Supreme Court said she abandoned her work because of the circumstances surrounding this case. And in fact, there was an express statement that she will no longer return to work. So there was no dismissal. In fact, there was
Mm-hmm.
abandonment of work.
Right, but still the ruling stands as she was illegally suspended.
Yes, yes. The suspension is illegal because there's no ground to suspend since she did not violate any morality rules of the school.
All right, so very, very interesting discussion, Yusek Javier. I'm sure a lot of OFWs listening or maybe teachers listening can gain a lesson or two. But just to sum it up, what's our takeaway from both cases?
In the Philippines, it's a pro-labor jurisdiction, meaning our laws are there to protect the employees. If there is an intention to suspend or to terminate an employee, the employer must strictly follow with certain procedures. For example, the termination of employment or even suspension, there must be a just or authorized cause to do so. And those just and authorized costs are enumerated in the labor code. And not only that, that is a substantive part. The second part would be to follow the procedural due process, and that is essentially providing the employee two notices. The first one is to provide the employee the notice to explain, giving the employee at least 5 calendar days to explain and to provide the reasons and state the defenses why he or she should not be considered to be violating any of the company rules. And second, the employee must be informed of the decision. That's the second notice. Without
Mhm.
compliance with the procedural due process, more so of the substantive due process, the termination of employment or suspension of employment may be considered illegal.
All right, and a very timely topic, Yusek Javier. We just celebrated Labor Day on May 1. And so these two topics, our previous episode on what constitutes an employer-employee relationship, and now we're talking about illegal dismissal. So sort of completes the whole picture of the employment process. We're very, very fortunate to have you with us in this past two episodes, Easy Caber. So thank you so much.
Thank you, Attorney Mike. The privilege is mine.
All right, and if you wish to read the full text of the court's decision, you can go to the Supreme Court website and e-library. Just search for Bison Management Corporation versus AAA and Dale P. Pernito, GR number 256540, and Bohol Wisdom School et al. Versus Mabao, GR number 252124. You're Steph Atendido Beltran, Supreme Court Information Officer, for this week's Roundup.
From the Supreme Court of the Philippines, here's the latest. The Judicial and Bar Council on Tuesday announced the schedule of interviews for the position of SC Associate Justice to replace Honorable Mario V. Lopez, who will mandatorily retire on June 4, 2025. A total of 17 candidates will be interviewed on May 14, 15, 16, and 21, 2025. Candidates are Court of Appeals or CA Presiding Justice Fernanda Lampas Peralta, CA Associate Justices Ramon Bato Jr., Ramon Cruz, Myra Garcia Fernandez, Nina Antonio Valenzuela, Maria Elisa D., Ronaldo Roberto Martin, Walter Ong, and Carlito Calpatura. Sindigan Bayan Associate Justices Carl Miranda and Ronald Moreno. Court of Tax Appeals Associate Justice Maria Rowena San Pedro, and Court Administrator Raul Villanueva. Other candidates are University of the Philippines College of Law Dean Darlene Marie Berberabe, Philippine Permanent Representative to World Trade Organization Manuel Antonio Tihanki, Tax Lawyer Attorney Maria Rosario de Leon Bernardo, and University of Asia and the Pacific Institute of Law Dean Maria Concepcion Noche. The Supreme Court has reaffirmed that testimonies from a spouse's family and friends can help prove psychological incapacity in cases seeking to nullify a marriage. In a decision written by Senior Associate Justice Marvic MBF Leonen, the SC Second Division declared the marriage of Jeffrey A. Green and Rowena Manlutak Green null and void due to Rowena's psychological incapacity. Jeffrey filed a petition to nullify their marriage, claiming that both he and Rowena were psychologically incapacitated. As evidence, Jeffrey submitted a psychiatric evaluation report based on standard tests and interviews with himself, Rowena, a mutual friend, and Rowena's mother. Ruling that Rowena was psychologically incapacitated to comply with her marital obligations, the SC emphasized that in nullity of marriage cases, psychological incapacity can be evaluated using statements from people other than the spouses, especially from those close to the allegedly incapacitated spouse. The SC added that as long as the totality of the evidence can prove a spouse's psychological incapacity at the time the marriage was celebrated, the marriage can be nullified under Article 36 of the Family Code. The Supreme Court has upheld the conviction of former Dapitan City Mayor Joseph Cedric O. Ruiz for corruption and misuse of almost 1 million pesos in confidential and intelligence funds. He is perpetually disqualified from holding public office. In a decision written by Associate Justice Ramon Paul L. Hernando, the SC's First Division affirmed the Sandigan Bayan's ruling, finding Ruiz guilty of violating Section 3, Paragraph E of Republic Act or RA number 3019 or the Anti-Graft and Corrupt Practices Act and Article 217 of the Revised Penal Code on malversation of public funds. The SC noted that if Ruiz had genuinely intended to use the funds to address post-election violence, he should not have requested the full amount allocated for the entire year. His action caused undue injury to the city, as it depleted the city's confidential funds and forced it to realign its remaining resources. The SC also held that Ruiz committed malversation when he used the confidential funds for personal gain. The SC has held a school civilly liable for negligence after a bullying incident led to the assault of a student during class. The SC Second Division, through Associate Justice Mario V. Lopez, found that Mother Goose Special School System, Inc. failed to address a punching incident involving 3 grade school students inside one of its classrooms. The SC held that the school was grossly negligent in handling the punching incident and emphasized that schools have a contractual obligation to ensure a safe learning environment. It also reiterated that schools have the contractual obligation to maintain peace and order within their premises and even outside campus during school activities. On April 30, the Justice Sector Coordinating Council, or JSCC, marked its 15th anniversary. Composed of the Supreme Court, the Department of Justice, and the Department of the Interior and Local Government, the JSCC was organized in 2010 to serve as a forum for coordination to address issues of common interest and a mechanism for the effective sharing of information in support of the planning and implementation of joint initiatives among justice sector institutions. Since 2010, the JSCC has established 16 justice zones across the country. The JSCC also organized a photo exhibit at the lobby of the SC Main Building, the DOJ Main Building lobby, and the DILG NAPOLCOM Building lobby, showcasing JSCC's achievements and milestones for the past 15 years. The photo exhibit will run until May 9, 2025. You are now up to date with the Philippine Supreme Court. I am Tiffany Doblatran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Karen Martinez, Jay Rimpilio, and May Sibal as researchers, and Brian Austria as sound editor, and Tyke Flores and Jerome Batumalake as web editors.